Any mention?
May I please, Your Lordship?
Yes.
I'd like to mention item number 5.
Yes.
Due to some personal difficulty, the conducting counsel could not appear before this Honorable Court, Your Lordship.
Here for the respondent number?
Respondent number 3 and 4.
No objection.
They are taking adjournment.
You're objecting?
Not objecting, my lord, because the senior is not here. Some difficulties.
You're supporting?
Not so.
Okay. On the request of the private respondent number, so and so. This is met after 2 weeks.
Respondent number 3 and 4.
Yes, 2 weeks after.
After 3 weeks, Your Lordship.
3 weeks. Okay, after 3 weeks.
Please, Lordship. This item number 14, Lordship, I just make to mention. I have informed to the private respondent also to government.
What is this matter about item 14?
This is regarding we are challenging the order passed by the Chief Judicial Officer, I mean CJM.
He wants further investigation into the matter, my lord.
Yeah, for acceptance of FIR.
Yes,
Against the acceptance of FIR without giving an opportunity, Lordship.
Old man.
This is not acceptance of FIR. This is he has lost the complaint sexual harassment workplace, Lordship.
Achha. So that complaint was not.
Inquiry was conducted. Then after that he has filed series of complaint. Then as per this, the act that court cannot take cognizance of section.
And out of the same.
It's not a cognizable offence.
Non-cognizant.
Non-cognizant. So police cannot register.
Yes, Lordship.
Without the.
Yes. Even the court cannot take cognizance.
Okay. After 2 weeks.
After Puja, Lordship, yes.
After 2 weeks on the request of the learned counsel of the petitioner. Item 14. Yes.
Lordship.
May I please, Your Lordship?
Yes.
Item number 7.
Yes.
May this matter be taken up after Puja due to some personal difficulty of the conducting counsel here?
Okay.
May it please the Lordship.
No.
If 7 is to be adjourned, then 6, then and they also until also are required to be adjourned, Your Lordship, because a similar issue.
Who are the counsels on those matters in this?
I am in 5, 6 and 7. I am the petitioner, and that 8.
Yes, yes.
8 you are there.
Senior counsel.
You have objection? Sure. 8 and
6, 7, 8, Your Lordship.
6, 7, 8.
Lordship, yes.
In item number 7 and 8, Lordship, the
You are
respondent
mentioning which item?
I'm mentioning item number 7 and 8, Your Lordship.
On the 6, who is the other side?
6, I am for the petitioner. And
6, nobody is asking for time.
see, this is connected, Lordship. Once that
Connected,
matter is
Your Lordship.
because there is an order to club together these 3
Okay,
matters.
7 and 8, you just write on the request made by
Respondent
learned
number 5.
counsel for the
says
private
5 and
respondent
6.
number.
Item number 7 is respondent number 5 and 6.
And then 8,
And item number 8, respondent number 5.
respondent number 5. You just say. After 2 weeks, on the request of such and such. And then 6.
6 will be listed along with that.
To be listed. Is there any order taking together? all
Another
six?
order is there.
Okay. Okay. 6 also after 2 weeks, yes, after 2 weeks. Because these are tagged, yes, along with, isn't it?
Along, yes.
Yes, yes. Okay. Okay.
Deeply obliged, Your Lordship.
Obliged, Lord.
Lordship, I put to mention item number 11, Your Lordship.
Other side?
No objection, Your
Here for?
I'm for respondent number 4, Your Lordship.
Your state, your state. Yes. Okay. On the request made on behalf of the private respondents, list this matter after 2 weeks.
2 weeks, Your Lordship.
Item 11. Okay.
Lordship, item number 12 also, Your Lordship. I have already informed the party. Let it come after 2 weeks.
12 also, after tweak, on the request of the learning counsel of the petitioner.
All right.
Yes.
Supplementary list, item number 1.
Yes, Mr. Sangma.
Please, Lordship. This is the case where both complainant and also the accused has filed the petition, Your Lordship. Now, what happened?
It's a joint petition.
Joint petition, not joint petition, but we make a party. There was a compromise. We make a party to the complainant, Your Lordship. Now, I will just narrate the fact.
Before my first thoughts, Lordship, this matter is being led by Ms. N.G. Sheila, Lordship, senior government advocate, but she's indisposed for today, Lordship.
Actually, state is actually.
You do not need a leader to lead you,
Yes.
do you?
Lordship, I just received the brief just now.
He is competent enough. He has very
Then
knowledge.
in that case, Lordship, if
He's
the
more than competent enough.
Yes, Lordship.
in that case, Lordship, if the lower court records may be called
This is
for.
already record is already called, Lordship.
No, what
It's there already.
will
Yeah.
do with this?
Charge it-
We'll just
charge
see
it will be filed.
what is the section involved here?
Section 364. I was alleged that I was kidnapped.
Kidnapping and you have compromise.
No, kidnapping in the compromise. In the complainant, he said that by bona fide mistake he filed it. He did not file intentionally without doing without
By
asserting.
bona fide mistake he filed the complaint.
No, Lordship,
He thought that he was kidnapped.
I'm withdrawing the word, but according to the compromise, he said that without ascertaining, he on suspicious ground, he said in the I have filed the FIR in the compromise.
He was not sure whether he was
Not
kidnapped.
sure whether I was involved or not. It was on the presumption, clearly stated on the presumption, mainly on suspicious ground. He has filed the FIR. Then that's why he don't want to pursue the
Person
case.
suspect that he has been
Lordship, that's for trial to decide, Lordship, whether that the person is the accused.
matter is charged.
Matter charge sheet, Lordship. Matter charge sheet, but yet to be the trial is start to be commenced and charge sheet, but they are supposed to be under the consideration of
Charged on the basis of suspicion.
on the suspicious, Lordship, because the charge sheet I have not seen because it is on record. However, I have the judgment and other thing because it's very clear, Lordship, because that person, the complainant who himself want to settle the matter to live with peace, together, in the complainant also, there is a judgment there.
You do not have to come to this High Court. You can do it by yourself.
No,
You are for the private respondent, Mr. Sheikh.
that I will satisfy Your Lordship.
You are supporting him. So why you are here? Go to the trial court, finish
No,
it.
because this is a non-compatible Lordship.
No, even then court can do. It
Non-compatible.
will not compound. You go and talk with the prosecutor, he will tell you the way how to do.
No, actually, that
482, you see, exercising, see. The problem is, difficulty is that once you exercise jurisdiction in this kind of cases, it will open a floodgate. And then if you, I do not know what decision you brought with you to refer or rely in this case. Just see, this in all kind of offences, settlement would not be accepted. It is only in cases where it confines, it is a private.
It's civil of nature.
Yes.
yes, but yes, here try just to be studied.
Kidnapping and all. These are offense against the society.
Complainant himself is saying that he has filed a lodged FIR only on presumption, only on suspicion.
Okay, then
and that is yet to be ascertained by the
Then your
court.
solution is not here, then you go to trial court.
Since the complainant is also is not denying that he filed the FIR on based on suspicions, and even the petitioner also is strongly denying the allegation against whatever is stated in the FIR. So that means, like Lordship, my only submission is that since it is not the case that these people, the petitioner, who against whom the allegation has been made, has been found guilty or found prima facie, the trial is yet to be started.
If we allow also, we will penalize the complainant here. They cannot just go and file one, FIR.
False.
Okay, and get this entire system to work for it and subsequently come and withdraw. You see, the police has investigated. They have taken pain in, obtaining evidence and all. Therefore, charge sheet has been prepared. And now you come and say we have settled. So you cannot just take the state machineries.
Yes,
Right.
actually, what I was informed,
Right.
actually, before coming to the High Court, actually, in verbally,
Complainant supports you,
they-
we just see which way complainant can be penalized.
actually, they both complainant verbally they have requested the police. They want to settle the matter, but police verbally said that
Verbally,
we
see,
cannot
but
do
then
it. That they have
FIR was in writing. And
FIR was in writing.
withdrawal in verbal. It's a verbal withdrawal.
no withdrawal, but there was a compromise. Lordship.
So that is what we'll penalize the group. We'll see it. Because senior commander is not here today.
Lordship.
But then that something has to be done that way, isn't it? The citizen should not have the right to just go and file one complaint and get this machinery to go and investigate the matter. And whenever it's charge sheeted, you come and you say we have compromised.
It is the complainant is
Something has to be done.
Yes, but the thing is like this, that events happen. That is not denied. Some things happen. Of course, maybe the kidnapper, but the complainant, as per the complainant, he said that things happen, the incident happened, but not these people. That is what he's saying. Some other people.
Whatever the case
Just
may
now
be,
you said
Lordship.
something else.
Exactly,
You said
Lordship.
it was on wrong assumption, it is suspicion.
Yes.
Okay.
Lordship, there was a case of
But then now you are
kidnapping.
changing. Okay.
Lordship. We'll try to.
If you change, and if you say that, then that is not a good case for quashing 482. If you say others, then it's okay. The evidence will basically make it out. It will project before the court, and then court will use section 319. Call them, make them accused. Okay, so we'll send it back for trial. Now you have said that actually it is not you, somebody else. So if that becomes a basis for quashing, we will not entertain it. We'll put you to trial, tell the trial court to find out who is the actual offender, and if he is not an accused, then court will invoke 319. Okay, we'll pass order then.
Lordship,
If you agree on that, it will be all right.
Lordship, I will satisfy with some other day with some judgment.
You're satisfied. Court is very much satisfied now with your submission.
Yeah, Lordship, because I have many more to say, Lordship. Since he's asking time, next time I'll prepare better. Prepare. Come.
Yes.
Lordship, I'll come up with the cite my judgments and everything, Lordship, because these are crimes against society and they should not be quashed as like that, Lordship. And like
Please see part. How much right a citizen has
Lordship,
to use this police by filing these kind of things, and what can be done in this kind of situation?
Lordship,
System cannot be taken for a ride by any citizen, isn't it?
Lordship.
Public money, public energy is wasted there.
Exactly, Lordship.
So that is where. If that be the thing, then you file FIR today against me, but then
Tomorrow I can just compromise, withdraw that thing, and
make the police investigate,
Lordship.
and depending on the outcome you take. You see, charge sheet has been filed, then after few days you compromise and all.
Lordship.
Police has to be paid for doing their duty, isn't it?
Lordship.
Yes, already. So that is thing for the time. Should not be something like that. That it should become a courts. Now many cases are coming like that.
Lordship, they just file
There
false
has to be a check.
FIRs
There
and
has to be a check.
later on they compromise.
Anyway, on the request on behalf of the state respondent, list this matter when? Tomorrow?
After 2 weeks, Lordship.
Lordship.
Now see he is going.
Lordship.
I got the indication and now you will avoid this court.
And Lordship.
Yeah, Lordship.
This is matter after 2 weeks.
Lordship.
Hearing item number 2.
Yes,
Land acquisition matter in a lot focused expansion of the national highway from Lone Stone side to Karo Hills. In 2012, they issued Section 4 notification, and apparently Section 5A opportunity was given to some of the landowners, and later on they abandoned that Section 4 notification. They were unable to issue the Section 6 notification. Later on, 2013, they issued Section 4 notification again.
I mean, old act.
Under the old act.
New act came in 2014.
2014. First January 2014, 2013 act came into being. And my lord, my case is the action was taken under the old act. Under the old act.
Section 4 was issued against 2013.
Yes.
And then?
Yes. And thereafter, Section 6 also issued. Now, thereafter, yes, in both Section 4 and Section 6 notifications, my name is not there. The three petitioners' names are, 4 petitioners are here, their names were not there. Subsequently, the collector issued Section 9 notice. There, the issue was notice to us, mentioning my name, my property also, and they asked us to appear. We went in appear, but personal hearing was not taken place on that day, saying that the number of people came there, and they did not call my name. So the next day, 4 petitioners put up an application that since you were unable to give us opportunity, give us one more opportunity. Then the collector office informed that we will allow you to check the record. We went for checking the report. They also did not allow us to check the record. Thereafter, they put out the RTI and they extracted the Section 4 notification also, Section 6 notification also there, and the report given by the extra assistant commissioner before Section 4 notifications. So my names are not there. Now my contention is, my lord, since the Section 4 notification notice was served to me, and my land was taken away, therefore the action of the respondent is wrong. So we filed a writ petition there. It came up for single bench earlier, and the single bench said, no, you should approach the special judicial officer. We argue that since Section 4 or a word was not passed in my favor, there's no question of approaching the special judicial officer. But the order was passed. We went to division bench, and division bench.
No, this whether the process was completed.
With others, landowners.
With regard to others, the process was completed. So there was an award.
There was an award.
Why not? You should approach the special judicial officer. Why is it good?
No, my lord. My
It's
name.
it's a kind of claim, you see. Like you say that my land has been, isn't it?
Yes, right.
Give me a land acquisition act. I don't know. I have nearly forgotten those things. The old one, not 2014. Land acquisition act is not there. Which one is there? Right. What are the procedures? See, section 9 or thereafter.
The reference is section 18. Lordship, may see the section 18 is the reference.
It is the reference. Yes.
It says that when a word is passed and the award is dissatisfied by the landowner, then they can put up application for reference.
Yes.
But in my case, my lord, no award was passed.
No. A word means a word in the matter. A word not in this. You say that has been finalized.
Award was
acquisition
finalized,
proceeding has been.
Lordship.
One minute. No, that is with regard to the claim. Section 30. See section 30. Why 18? The ownership will be section 30, I think.
But here, it is not with regard to ownership.
Okay.
The dispute.
Okay.
The government said that they didn't take the land.
Yes, that is section 30 will come in your case. Section 18 is for the purpose of enhancement. And section 30 is the apportion. When a word is prepared, and if your name is not shown, then you say that I am also a claimant. Then in such a case, you should put up your case before this thing, and that will be referred to the special judicial officer. That is what the law is.
Well, I'll show from my record, why I was not approaching the special judicial officer.
Is there any order earlier passed by the court?
Yes. Single bench disposed of my petition, directing me to approach the special
You challenge it
judicial
in
officer.
division bench?
Yes.
Did you challenge it in division bench?
Yeah, we went to division bench. Division bench has set aside a single bench order, saying that there was no award. The question of section 18.
Section 18 is not coming here. Section 18, how section 18 will come here?
Therefore, matter was remanded back before the single bench. Now, Lordship has seized the matter.
Here, how it is?
Yes. May I just place the single division bench order?
Section 18 is no question. Why section 18 come here?
Well, Lord, may I take just 11 portion. That was the Lordship, can you see para 8 of the judgment, the next page. It says, when the petitioners have not received any compensation, question of non-payment of adequate compensation does not arise.
Yes.
In our considered view,
adequate compensation. Here, that is where section 18 comes.
Right.
That is where section 18 comes.
Right.
But then section 13 operates in a different area.
Let me just complete this one portion. In our considered view, the case has not been appreciated in its right direction. On the basis of pleading, it is not clear whether compensation vis-a-vis properties was as claimed by the petition has been awarded. The order as passed has been processed or incorrect facts and decided in incorrect observation, which render the order as unsustainable and is hereby set aside. The matter is remitted back to the learned single judge for deciding the matter afresh. So this was the order, therefore the matter came back before this honorable court. And Lordship is referring to section...
What is the single bench order in that thing, which was set aside? Is it there?
Bench order, my lord.
Let us see just what was the thing.
The single bench order.
Single bench.
Worship, give us some time. My lord, this copy is not here.
I'll just return back to you.
My lord,
Just wanted to.
this is one page out. One page out. That order was found on the basis of the prayer or argument advanced by the State Council.
He has not received adequate compensation.
Yes. So because of that, we prefer appeal.
See, receiving compensation and receiving adequate compensation are two different things. And not receiving compensation is another thing.
Right. Correct. So that order was upset by the division bench.
That is all right, but then the thing is that I do not know. Now,
Lordship is referring to section 30.
Section 30, 30.
30. May I just
The apportionment, that is where thing comes, where there are several claimants. And if you find your name is not included in the list of claimants, then you avail that.
Well, section 30 is a dispute as to apportionment.
Yes.
When the amount of compensation has been settled under section 11, if any dispute arises as to the apportionment of the same or any part thereof, or as the persons to whom the same or any part thereof is payable, the collector may refer such dispute to the decision of the
Yes, that is what.
the court. To the court.
To whom it should be payable.
special
That is what it, under section 30, that is what. That is what the determination. That is what the law is.
No, in my case here, a vote was not passed in my favor.
That is why section 30 comes. If your name is there in the award, and if you have any challenge, any dispute with regard to the rate, then section 18 comes into play. There the question of adequate compensation comes. For you, there is no adequacy of compensation.
Yes.
Here it's a case you have not at all received any compensation because your name is not included in the list of claimants.
Right. And government say that my line is
Probably,
no.
Honestly, Mr. Sanglisho, I am also out of touch, especially with these old things and all. Just, but then there is a process. Probably Mr. Khan would be very much acquainted with that. When your name is not included, what you do?
My lord, I will open the pleadings. I have some citations are there in these circumstances. Even this oral court can direct the commissioner to conduct the inquiry and give a report. Some decisions are Supreme Court decisions are there whenever those disputes are there. Matter is not necessarily related to the.
In what situation?
Well, whether the land is taken or not, whether it is in the possession of the respondent or not, in those circumstances, there are Supreme Court judgments are there. The High Court can direct. The court can direct the judicial officer or any commissioner as a normally district judge to conduct the inquiry and give a report to ascertain. Because the civil court is outside under the LA Act regarding dispute arising from the Land Acquisition Act. Now, in my case, the government also admitted that Section 9 notice was issued. Until they did not revoke that Section 9.
But then, see, you think this is final after Section 11 comes into operation, not this thing. Section 9 is basically, again,
before Section 11.
Section 11. And when Section 11 is done and your name is not there, then there only Section 30 comes into play. See, there are two situations. You see, that is where I do not know apex court decision which you are saying we have to go about that. But then your case, like, did you represent your case before the collector?
Collector, we definitely approach.
Have you filed any application saying that I also have a land there?
Right.
My land has been acquired.
Right,
no compensation has been paid.
It was there.
When it was done?
It was there. It was into my lord.
It was done before the preparation of the award or after preparation of the award?
No, that is after my lord.
When? How long?
Lord,
This is something.
See that representation or the application allowing them to give opportunity.
Mr. Khan, what is the stand of the state in this case?
Lordship, the stand of the state is very clearly, Your Lordship, on that we have not acquired his land, number one. Number two, Your Lordship, if you just come to our affidavit, para 15.
Just yes. Mr. Sanglisho has not finished. I'm just asking, just for the helping my application of mine, that what is the stand taken?
Lordship, what has fallen from Your Lordship, in fact, that is the correct position of law.
Well, I do not. Probably I thought
Tentatively, because so.
See, the earlier decision, if you see, Now the division bench has interfered, saying that since there was no compensation, the question of inadequacy will not come. But then if you see the order of the single judge, here submission was made by the counsel for the petitioner that I have not received adequate.
Lordship, very correct. Then, it's a judicial order. It's a judicial order.
Meaning thereby he has received something.
He received something, and the consequences of that is Lordship.
What is your submission?
My lord, on that day, my lord, my colleague appeared.
He should have filed a review.
Mr. Sangri, so I can understand.
No.
But then you see, that
was
has
the
been
argument of the
recorded
learned AG that time, and he repeat that same argument before the learned division bench that I should invoke the section 18. Section 18. That was the argument of the learned AG at that point of time. That was
Which section
turned
18
out by the
not
division
at all
bench.
come here.
Lordship, first thing they should have reviewed this order if there was something wrong statement. Single bench order. Instead of allowing the mistake to be corrected on the adequate compensation.
Now the division bench has to come into play and matter has been sent back again.
Send back.
Now what we are confined to this is that, say, like whether, you see,
Lordship, legal issue.
petitioner has at all represented himself before the collector or not at the
Section
time of
11.
the
Absolutely.
And then whether the process, if collector has not followed the process which he has to do, you see, it is not that we just confine reading one particular section. That will not go.
Not will happen.
There has to be chronological reason.
Absolutely
Okay.
correct.
So this is not that this court will just pass any order by listening to what
No.
Mr. Sangresh is saying or what you are
Absolutely.
saying.
No, absolutely correct.
Okay.
Lordship.
Now, just we have to understand the process how it is done. It seems like here we are in litigation proceedings. There are steps, especially under the old.
After 9, Lordship, the matter ended at the stage of 9. Because they did not file any objection or no, they were hearing.
That is what they should have filed some application.
And that is at
for
para
inclusion of
15,
them.
Lordship. States para 15. Lordship, can you see para 15?
It's okay. We will come to your thing, merits of the claim, but then that is your stand is that
Your Lordship.
that they have not filed.
They have not
So
filed.
there is no question of making any reference under section 30.
Section, and the situation.
Under the
for-
old act, there are two main references under section 18 and section 30.
Lordship, if there was anything happening at the stage of 9, then they would naturally have the right under 11. They chose not to do anything on 9, and so there was no occasion for the state to consider anything at 11. And they allowed 11 to.
When the award is prepared, when the award is when award was prepared when in this case.
My lord, in 2013.
That's it, 2013.
I think the record, I think the learned AG will know. But
Let
may just start
let him
the,
just complete. Lordship.
lecture
Yes.
1, my lord. Page 24.
So many annexes.
My lord. Page number 24. This was the letter 2010 issued by the collector.
Yes.
Requesting the district council, KJDC, to participate in the survey or conducting the inspection. Though district council has a less role regarding this, but those days, my lord,
Was it correct to be done?
right, my lord. So this is the invitation of the collector himself.
The problem of lawyers is that, you see.
Well, this was the letter. So he requested the district council and the second page, page 25, my lord. District council responded, and they have deputed 6 officers of the district council for conducting the survey. My lord, this is 2010.
These letters will carry any meaning to you.
It will not be. But my lord, how it culminated
No, after that you have taken the stand in the division bench. What legal standing it will have in these letters?
my lord, this can be ignored. But chronologically, I am opening the fact of the case.
The court is, you see, creating obstacle in the path of your argument.
Well, I will satisfy. My lord. I'll satisfy.
Achha, anyway,
it is my
then-
duty to my lord to disclose the entire facts.
Yes.
It may be not relevant, or it may be, my lord, against me, but it's my duty to disclose, my lord. Now, my lord, on the basis of that joint survey, page number 26, my lord, the report was prepared. And by this report, my lord, all the signatures of the deputy commissioner, department, district council are there at the bottom. And this list, my lord.
There is a land valuation, statement of land valuation.
Yes, my lord. Now, these 59 landowners' names were mentioned in this report.
You are not there.
I'm not there. I'm not there. My lord. And thereafter, my lord, what happened? I have not opened read the entire name of the parties. So, my lord, thereafter, there was a complaint by many that the names are not there. Many names are missing in the process.
Yes.
Therefore, district council, page number 74, my lord. District council by itself
Yes.
conducted the survey according to them. Page number 74, annexure 5.
Yes.
And the report was given to the collector. And in this, my lord, report given by the district council, for, my lord, 60 landowner names are mentioned. They say they are the landowners for this highway expansion. They're entitled for compensation.
Your name is not there.
Here, my name is there. Now, my name, if I may take, my lord, serial number 45, 48, 49, and 50.
In this, at page 75.
My lord, at page 75. May just come to...
Your name appears.
Yes, relevant portion reflecting my name. It is the
Now, this is the, what was the first one? First one was also a list of?
list of the landowners.
Then this
Submitted
second one
by,
is?
jointly submitted by the Deputy Commissioner Office, District Council. There are only 56 names. My names are not there.
In the first one.
In the first one.
And then page 74, this is the second one.
And this is page 75. 74 is the another list prepared by District Council, GHATC, saying that
That is in modification of the earlier list.
maybe in modification or addition, maybe. But the names are
Those names which were there
yes.
in the first one,
Yes.
whether those names appear in the second one
Some
also?
of them also appearing in this second list.
So that is a modification.
Maybe modification.
You
Modification.
cannot take stand and maybe you have to say this is your case.
It is a modification. I must say it is a modification. Now the competence of District Council.
Second list includes your name.
Second list include my name.
Yes.
Now may I show my name where it is reflected. Well, that is page. My lord, page number 86, Lordship, can you see that table?
Yes.
Yes, 86, serial number 45, Lordship, can you see?
Srimati Mary D. Marak.
Marak.
Yes.
Her particulars are there. The properties are mentioned: kacha house, shop, trees. Everything is mentioned.
Okay.
Writ petition number 1, and writ petition number 2. The next page, 87, Lordship, can you see? Mr. Nicholas C.H. Marak. And
How many petitioners are there?
four petitions, only 4 of them. 49 also, and 50.
Yours is 45, 48, 49, 50.
Yes, my lord.
Yes.
So the details of the property also mentioned there.
Yes.
So this was submitted to the Deputy Commissioner. And, my lord, and thereafter, my lord, the page number 96.
1 minute, Mr. Samaris. Does it not, it refers to two different, see on the top things, if you come to first, your first list,
First,
is
joint-
26, 26 means come to the typed copy,
page number, Lordship.
36, come to page 36,
Page number 36.
a statement,
Page number 36.
that is a list
List.
of the owners, land owners. Page
36 type copies. Yes.
Yes. Now there you say statement of the the land valuation required for the construction on Nongstram to
Yes.
so and so land, state PWD road in Songsa, Aking land, number
Yes.
so and so. It refers to this number is Garo Hills,
Yes.
Meghalaya 2011-12. Now come to the list which you are referring now. This has
So it is 74, Lordship.
the page which you have referred now. The page 87,
Oh,
86, 87.
yes, 86, where my name reflects.
No, that is okay. See the top. Writing on the top.
On the top,
Yes.
inclusion of names in the statement of valuation.
Yes, go ahead, go ahead.
On the fruit bearing and other trees acquired for the construction of Songsak, Sunset Belgic double lane, such.
See, there seems to be difference so far as the area or the project is concerned.
It is a same.
It is not this 2036 and 86 may not be relatable to the same proceeding.
Lordship, not same proceeding, Lordship referring.
Same land acquisition proceeding.
It is same process.
So, but then why it has two different numbers? See on the top also. Then you see like construction of Songsak, Wagopogre, Baljak double lane street, PWD road.
Yes.
Songsak, Wagopogre, Aking land number H44, M number so and so 55 East Garo Hills. But then the earlier one doesn't. It's not that.
Maybe when crossing the stretch of highway expansion, maybe different names of the land.
If it is for different stretch and if it is done by different notification, this may not fall under same thing.
But it is under the different, into the same process. The respondent also did not dispute that one. It's the same process.
We do not know whether that has been at all noticed or not.
It is same process.
Because if you can, one matter can be argued on the premise of that is section 18 thing and reach up to division bench, then this is also not something not unusual.
It is the same process. It is the same process. They may maintain different number or different names of the land are there.
Normally it is not maintained. Different number is something it refers to file, it refers to proceedings and all. The government record, it should not happen. It is not something casually that we do here.
Now, Lordship is referring to 36. This is maintained by submitted by the joint committee comprising of the collector office, the district council, and other PWD also.
And this page 87,
number this way.
and that page 87, which
is the number maintained by the district council. Whether it is exactly correct or not, but this is the document of the district council.
Well, then whether it is with regard to the same thing or not.
But anyway, it is the same thing, man.
Anyway, proceed. Anyway, what?
So my name is right or wrongly reflected in district council.
Yes.
Paper. So it may not confer right upon me. Now, thereafter, what happened? The issue, the page number 96.
Yes.
Another list, my lord. 3 lists are there.
With regard to the same proceeding?
Same proceeding. Now, another list submitted by the EAC, yes. My lord, page 22nd November.
This is the last one. This is
the last one. Last one. Now, it says submission of report on spot verification of claims and objections in connection with acquisition of land for due laning of Shillong Nosten,
yes.
section such.
This is a different area.
Wrong check.
Different area.
But it is a stretch. It is one stretch.
See, stretch means, but then the whole stretch doesn't belong to you, isn't it?
No, not belong.
It may happen that one
stretch,
stretch is acquired by one this thing. Otherwise, why there should be different name?
It's a long stretch. Different land owners are there, my lord. Different names of areas of there.
No, but then whether acquisition is by the same notification.
It's same procedure.
Altogether, how this? It means these three lists basically refer to 3 different areas.
No.
So it is not a thing that the first list was for the entire part. Second list is a modification of the first list, which is also for the entire part, and third list also is. It is not that. It means the first list was for one part, second list was for another part, and third one is for third part. Is it something like that?
Oh, my lord, according to me, this is a continuation process. I think collector will know. Collector is right authority.
How we will know, Mr. Khan, all those things? If I do not get the fact remains confusing, then what?
My lord, the subsequent annexures, pleadings from my side, the AG side may be very clear. And if this is the lordship may ascertain.
No, if your document says something else, I do not know.
Because the state also not denying that one.
See, this court, until and unless it gets facts properly, it will be difficult for the court to decide.
Right. We have, it is our duty to make it very clear.
Already the court finds that it is quite confusing.
We will try, we'll try to.
What is the stretch of land which was supposed to be this thing? For how many kilometers this acquisition was for how many, what is the total stretch?
My lord, in that distance of acquisition, I'm not aware. The state is supposed to know, man. I'm concerned for my land.
This is your case.
I'm
Burden
concerned
is on
for
you.
my land.
Burden is on you.
My concern is, for my land, it's my duty to prove.
If you
with regard
do
to
not
my
know
land.
that, then it becomes difficult.
And my lord, it is a document of the government, not my document. I'm not the author. I'm relying on the author.
This is document of the district council. This district council is a party here.
District council is a party. They file a
Who is the
affidavit. The proforma respondent, my lord.
Who is the? Huh?
Mr. Sujit was there, but he's a proforma respondent only.
The facts seems
And
to
in
be
his
quite-
affidavit, he said that yes, my names are there in their report. But the government say that
See, the question would be that what this court would like to know, whether this 3 list referred to the same land or for 3 different lands.
my man, the same land. Now the section 6 and section 9,
Wait.
they say that they are relying on the list prepared by the page number 96.
Which
Page 96. Page number 96 list.
96 list?
Yes, they
is
rely
final
on
list.
this.
That is the final list.
Yes.
So earlier 2 list loses its relevance.
May lose its meaning.
It becomes
but
insignificant.
It may not. And they relied on this. That is the affidavit. They stated that also in the affidavit. Now, page number 96 is important.
96.
Well, collector himself. Now, it says, in pursuance to the order in the later quoted reference, I have the honor to submit here with the report on spot verification of claim objections in connection with the acquisition of such and such. So this was submitted to the collector by the EAC. Now, in the lease, my lord, the lease here consisting of 95 landowners.
This final list.
So, yeah, in the final list, 75 landowners.
75.
75. Now, those serial number maintain 75s, but actual landowners are only 71. Now, 4 names are missing in this list.
Now, how do you say actual owners are 75?
My lord, when we count the serial number. Now I will show, my lord. Lordship, can you see page number 91, 97?
Something
It started from serial number 1.
Yes.
My lord. Now may I continue? Till page number 109.
Yes.
Yes. So the last name is number is 75.
Yes.
So 75 landowners' name mentioned.
Yes.
That is the claim of the EAC submitted to collector. Now 4 names are missing. Now I'll show. My lordship, can we come to page number 104. And this is my contention. These my names are strike out or deleted.
104. Yes.
104.
Yes.
The last number is, my lord, 45.
Yes.
Now come to page number 105. It is supposed to start from the 46, but it started from 50. So 46, 47, 48, 49 missing.
So we do not know whether this is a page is missing in the list or not.
No, it is not missing. Government did not deny. RTI also.
See, what?
This
what
is the
you are-
RTI.
See, if because this is missing, if these numbers are missing, does it mean that your name is missing?
That is why.
What would be the presumption?
No, that is
Under
my
what law?
that is my claim.
That
The
is
state
your
did not
claim.
deny.
Claim has to be a basis.
State has to
Just
deny.
because you say that, see, these numbers are missing, and I am saying that my name should be there, then the court will agree with it.
Court is not necessarily agree with me, but Lordship kindly appreciate the reply of the government in the affidavit. If the government denied, but that is another. But government is not denying this.
Government is making out a case for you.
Government is not denying. And admittedly now 4 names are missing. And my contention is that my name is Adi. So make a specific government, they did not deny. Thereafter what happened? Lordship kindly see page number 110. Section 4 notification.
This is a list which came prior to section 4.
Yes. And they say that they relied on this list given by the EAC.
Where they say? In their affidavit of opposition.
Yes.
I'll come to everything. Now the EAC list, admittedly, it is only 71 names.
No, but then EAC list, whatever it says, have they prepared a list of claimants pursuant to the withdrawal of the land acquisition proceeding?
That is what they are saying. They
After completion of section 9 and section 11, there has to be a list of claimants.
Right.
Where is that?
Now,
Prepared
what
by
is
the
law?
collector.
We are looking to the order passed in 2013. Now, I'll come to the affidavit. In 2012, my lord, from the beginning, I made a short submission. 2012, they issue a section 12 notification and allow the landowners to come forward for objection.
That is what the law is.
Yes.
That is the requirement of law. Calling for landowners to this thing, file the objection, all that is a requirement. That is the mandate of law. Law says that has to be
My
done.
lord, therefore I say, Lordship, earlier section 4, 2012 section 4 notification, they issued and they allow the landowners to come under the umbrella of section 5A, that is objection, right to be heard. And later on, it was not finalized.
Section 5A is against acquisition.
5A is objection against the acquisition. whatever.
Acquisition, not with regard to the ownership and apportionment and
Right?
you see.
And whoever against objection,
all these
whatever,
are
they can
different,
come.
different parts. Yes.
Yes, they can come. Because normally section 4 notification is supposed to list the name of the landowners. Supposed to mention the area of the land.
Area of the land.
Area of the land.
Landowners is not required to be mentioned in section 4.
It is not, but normally they do the preliminary survey and ascertain the landowners also, and they mention normally.
Section 4 only says about the location. You see, like the
Well, it is not statutory, it is not mentioned, but that is the, now they upon, earlier section 4 notification, it was dropped. Now this section 4 notification 2013, Roshmgani C, 14 March 2013, Roshmgani on the top,
yes.
my lord. Here they have issued and the landowners, only 56 landowners' names mentioned.
That is irrelevant. You see, section 4 should not name the owners. It should only mention the area.
Therefore I say, my lord, I do admit, the statute did not
No,
impose
this
the
is not a
government.
fault by you. It is for the state. I do not know which way. This is section 4 does not require the name of the owner should be reflected there.
But that is the. But normally when they do, for the sake of a smooth acquisition process, they do mention, and they say they mention. Now in the affidavit they say that section 4 notification, we relied upon the lease report given by the EAC. Now if they relied, maybe they are supposed to mention 71 landowners. They did not mention, only 56 landowners name mentioned. Now this notification, section 4 notification,
How many are you are there left then? 56. Out of 75, 56 has come. Or maybe 70, 71. 71, 56 has come.
Well,
So 15 left out.
15
The
left.
15 are petitioner here.
No, only for 4 of them are here. Only 4 of them are here.
Where are the rest 11?
My lord, that it's amazing this late acquisition process. I'll show another section 6 notification how it turns out to be, my lord. Roshim kindly see
Section
page
4
number.
contains some name, 56 names, and then
My
actually, just tell me the facts. Okay.
Yeah, and Roshim kindly come to page number 112.
102.
112. My lord. They invoke the urgency clause. My lord, may I come? May I read at the bottom? In exercise of the powers conferred by section 17(4) of the Act, government have decided that the view of the urgency of the project, provision of section is done with. There is no question of giving opportunity to me. Therefore, the learning AG said that opportunity was given. I never come forward.
Opportunity not at 5A. 5A, what 5A is?
5A, my lord. 5A is in fact 5A is a very important provision.
Come, let us see what is 5A. Let us come to 5A.
Hearing of objection, my lord. Well, any person interested in any land which has been notified under section 4, subsection 1, as being needed or likely to be needed for public purpose or for a company, within 30 days from the date of the publication of the notification, object to the acquisition of the land or any other land in the legality as the case may be.
Yes.
Objection under, my lord.
So then, see, this is what you say section 5 is not required. That has been because of the emergency clause.
Emergency.
Yes.
Therefore, there is a scope for the landowners to raise objections.
With regard to the acquisition.
With regard to acquisition, that is true. With regard to acquisition, the door is closed for us and other landowners. We have no right to object. But that is the effect of the urgency invocation urgency clause. Now, this is the, well, thereafter Therefore, the claim of the respondent in the affidavit that adequate opportunity was given to the landowners is absolutely not correct regarding this. Thereafter, my lord, page number 113, section 6, note declaration. Now, this section 6 declaration, my lord, 23rd May 2013. Now, surprisingly, 120 landowner names mentioned. Lordship may keep in mind, EAC report contains only
71, 56, now 100 and...
Right. How, my lord, how additional names come into the, my lord, included there? They don't explain.
Anyway, it doesn't make out your case.
Well, it will not help me, but I have to, my lord, place a clear picture, how it evolves. How it evolves, my lord.
It's all right. But then
Now-
which way it adds to your case? That is what.
No,
Are you alleging malafide?
my lord, my case is, my lord, my land was taken, record manipulated and striking out, and appreciating that my land is there. Therefore, the issue notification, section 9.
If you say about the manipulation and all, how this court will give a finding on that?
No, my lord, I'll come to that point. Your Lordship, with me. Lordship may come to page number 125.
Lordship, let me address that issue for manipulation.
That is exactly the court will be interested to know.
It will be wasting court's
Now
time.
this is that submission has come. Now this said that they have manipulated the land record and all.
Otherwise, we'll be wasting court's time.
No. My lord, the record is
That has been done. Then
Record-
I think you have a remedy under criminal law.
But I'll come to that point.
Absolutely.
But
Now see,
Lordship may
this will go as your submission. And then have you lodged any FIR and all in this matter?
My lord, I make submission from the records. Lordship has seen page, my lord, 64.
If you are finding out something from records, then you should take appropriate step.
My lord, what remedy, my lord, I will take by approaching the criminal court or the police. My grievances with regard to a denial of compensation to me. My lord.
No. Then how you will have to establish manipulation here?
But my record itself says, record is
See,
shows.
to establish manipulation and all, there has to be a criminal investigation, isn't it?
That is different. As
High Court will not call for the records and see where it has been struck off and where whiting has been implied and which name has been entered. This is not the duty of this thing. The High Court.
My lord, how Lordship, according to me, with due respect, my lord, Lordship may kindly appreciate the records. And the page number 86 we refer, Lordship has seen that certain numbers are missing.
One page is missing.
One page
so
is
to
missing.
say. Certain numbers is missing.
And I make a specific government
Now
petition.
even if we say that is yes missing, what it is proved, which way it becomes a point in your favor?
In my favor, because in my petition I make a specific government.
Then you would like to tell the court that court should give that in view of this there is a clear-cut manipulation on their part.
But government is supposed to deny.
Do you expect this kind of
My lord,
finding by this court?
Lordship, my contention is names are missing, and these missing names are mine. Even this is admitted through RDI. So this is the contention we take in the petition.
In the RTI, they say this missing name is yours.
My lord, it didn't
The
say.
RTI, they say missing name, so your name is yours.
The records supplied to us through RTI clearly shows there is a missing names.
That is what you are saying. We have also seen missing.
Right.
Clearly, it's missing.
And we will see the reply of the government.
Exactly the four petitioners here, four names missing.
Right. And government, we will see later the reply of the government. If the government deny, then there is a disputed or manipulation. This is a wrong forum. I'm here. But if there is a clear admission,
and then
no denial.
See, when this addition comes from 71 to it becomes 120.
120.
Then how it happens?
They will know, my lord. The collector will know how it happens. Whose name they are incorporating. That's why, my lord, the process. Therefore, I am elaborating the entire facts.
They have deleted your phone names and they have included extra another 20, 30, 40 names.
30, 40 names.
So they are totally biased against you, just in order to deprive you.
30, 40 names, my lord.
That is what your case is.
My lord. Yes, my lord. And now, Lordship, can you see page number 125? All the previous papers, my names are not reflected.
Page 125, yes.
125.
Yes.
Now this is section 8, section 9 notice.
Yes.
Now notice is hereby given to this PK. These are the name of the land, such and such. Of such and such, of trees, such and such. Assam type 2. The content I may not take a long time. All persons interested in this land are hereby called upon to appear personally or by agent on such and such. Aim to state the nature of their interest in land and the amount and particulars of their claims to compensate for the same, and their objection, if any, to the measurement made under section 6.
Yes.
Now, my name is mentioned there, my lord, at the bottom, my lord.
Meridi Marak.
Meridi Marak.
Yes.
This notice was given to me. The particulars of my land also mentioned. Assam type also mentioned. Now, therefore, assuming my
That
lord.
is the format. Where it is Assam type mentioned. Assam type 2.
Assam type 2, my lord.
But then this is a format. It has been filled up.
But therefore, if they fill up an issue notice to me, requesting me if I have any objection regarding the acquisition of this property.
It's okay. Section 9 has been this thing. So it
Right.
appears that your name was there
Yes, my lord.
in the list of claimants.
My lord.
May not be in the final list, but then it was there.
My lord.
Okay.
And the next page is also page 126. Seconded petitioners. Lordship kindly see. Land number trees, 820 trees. But after thorough survey, my lord, they are issuing this. Assam type 1, Mr. Nicholas, my lord. The next page, 127, 50 trees. My lord. And the last read petitioner is page number 128.
Page 1?
128.
Yes.
830 trees. And those particulars are there. Now my case lies here. Here's my case.
Yes, then
if I don't have a land.
It's all right. Then your name is there.
Yes.
And then thereafter?
Thereafter, my lord, what happened? Lordship,
when award was prepared under section 11?
This is before preparation of section 11.
Then that is definitely section 9 comes before 11.
Right. Now, before I go to further annexures, Lordship permits me, shall we look together the section 9? Section 9 of the Inquisition.
Yes.
Now, may I take my notice to person interested. The collector shall then cause public notice to be given at the convenient places on or near the land to be taken, stating that the government intends to take possession of the land, and that claims to compensation for all interest in such land may be made to him. Such notice shall state the particulars of the land so needed, and shall require all persons interested in the land to appear personally or by agent before the collector at the time and place therein mention such time, not being earlier than 15 days after the date of publication of the notice, and to state the nature of their respective interests in the land and the amount and particulars of their claims to compensation for such interest, and their objection, if any, to the measurements made under section 8. The collector may in any case require such statement to be made in writing and signed by the party or party agent. Collector shall also serve notice to the same effect on the occupier, if any, of such land or on such person known or believed to be interested therein, or to be entitled to act for persons to be interested as reside or have agent authorized to receive such notice. Now, therefore, this contemplates, my lord, serving a notice to the occupier or the interested person. Admittedly, my lord, under section 4, they conducted survey. Section 8. After marking survey, everything, Lordship, can I see section 8 also? Land to be marked out, measure, and plan. Lordship. The collector shall thereupon cause the land, unless it has been already marked out under section 4, to be marked out. He shall also cause it to be measured if no plan is made thereof, a plan to be made of the same. Now under section 8, they have to conduct a survey, mark out, and plan over. Now the notice itself said after section 8,
This all follows after declaration under section 6 is published.
Yes, yes.
Section 6 basically conveys the final decision of the
Final
government
decision.
to take over.
Right.
Section 4 is nothing. Section
Yes.
4 is intended.
Is a preliminary
Yes.
nature, subject to correction,
Yes.
abandonment, whatever.
After section 6, government also has the right to take over also.
Yes,
First,
my lord.
they can enter there.
My lord, they can enter. Right.
And
Section.
thereafter, after declaration, then section 7, section 8 comes into play.
Yes, comes into play.
Yes.
And now section 9. After they come to know the nature of the land, everything, then they give notice under section 9.
Yes.
Yes.
That is for settlement of claims.
Yes, my lord. Therefore, my name was not there in section 4 or mainly section 6.
Whatever it is, but then you have
Now-
been given section 9 notice. So whether it is section 4, you are there or not there, it's immaterial. It is immaterial. So far as the
Right.
process of acquisition is.
Right. Right.
But then what matters is that what happens after section 11 is done.
Right. Right.
Award is 11 or 11A? 11.
11. Award is 11.
That is what. That is where.
Award is 11. And
So you cannot ignore that you were ignorant of the process.
yes, yes.
Sorry, you cannot contend. I'm not saying this thing. You cannot contend that you were ignorant of the process.
After I
You
received-
had the notice.
Right.
You have received the notice.
We received this notice.
You received after section
We
9.
received this notice.
Right.
We received this notice.
Okay.
And therefore, my lord, since they fixed on 19 July for hearing,
Okay.
we appear, my lord, and there was no hearing on that day. Therefore, we put up this prayer again, page number 129.
Yes. You were supposed to appear by 15th,
By 19 July,
19th July.
my lord.
No, this notice is 9 July. And
19 notice was 9
then,
July.
19 July. 19 July.
Yes,
Then in September you write.
my lord. Now, no, on 19 we appear. We whole day we were there.
Where is that thing?
Well,
What basis we can say we have appeared?
The state ministry, my lord.
Your statement.
Yes, my statement is there.
Not supported by record.
My lord, no, there is no other materials to support. But I was there very much.
There definitely,
Well.
if you take part, there will be registry maintained in the office of the collector, where the signature of all the
Right.
person or their agent would be taken.
Right. Normally. Whole day we were
It is
there.
claim with regard to money.
Yes.
So everything has to be maintained properly.
Right. So we were there whole day. We were never called for by the collector.
What is the reply to that contention?
My lord, it is silent.
Yes, sir.
I'll come now.
Silence means admission.
My lord, the law, I don't need.
That is what the law is.
Is it, lordship? Now, page number 129.
Yes.
May I read, my lord?
Yes.
Now, with reference to the subject cited the caption above, we stream this such and such. Well, I'll take the second part. That we are genuine owner of the land situated at Songzal Sunset under the state and sunset matter. That being called upon by the letter dated since 9 July on sunset, we have turned to the concerned authority for hearing. We have been aggrieved to receive certain information from concerned authority that the list of inclusion of our names in the statement evaluation was found lost, and we returned without attending the hearing. That we have approached the dealing authority and requested them to search for the lost list. On being asked repeatedly, the dealing authority have searched for it, and we have been informed that the lost list of inclusion of our names is found. Having found the list, an SDC in charge for the revenue is also transferred to pursue the work without delay. With new DC in charge, we submit application. Therefore, in view of the above stated facts and circumstances, we are aggrieved landowners have sincerely request you, Your Honor, to kindly fix another day for hearing and to compensate for the encroached land for which act of your kindness and such. So initially they said they lost the list containing my name. So
When this application was received by the office?
My lord, but that reflection is not there.
No acknowledgement. What is state's reply to that?
This with regard to this, but there is no specific
Now,
answer to this, my lord.
when was the hearing took place subsequent to the section 9 certain notification?
But it was supposed to take place on
19th July. 19th July process was complete so far as section 9 is concerned. And then when the award was prepared?
Award, my lord, that I'm not aware when they have prepared the award. Collector.
Mr. Khan, when the award came in this matter?
Well, with due respect, land acquisition proceeding is involving full of corruption. Very, very sad to say.
You see, it was not that actually right at the beginning, but in the middle it has happened like this. Now, these kind of things, that every time publication of section 4, section 6,
Changing.
and that is with a containing the list of claimants, this has never been done. This has never been done like this. It is normally section 4, section 6, after declaration, you see, thereafter you proceed to prepare. Once you make, identify the law, demarcate the law under section 8, right? Then before resorting to section 9, you prepare a list, and then after section 9, if there is somebody left out also, they come in. That is what the law is.
Right.
Now, even if somebody is missed after section 11, that is where section 30 comes. Okay. So one thing is that you had a notice under section 9.
Yes.
Now you cannot now come and say plea ignorance of that.
No.
You see.
Ignorance.
So now what would depend upon that, what action you have taken. Now you are called upon to appear in the month of July.
Yes.
You write an application in September.
Right. We appear thereafter.
No, but then there is no immediate lodging of any representation.
The next one is that my lord.
Anyway, whatever it is, we'll see to it.
The next one is that. And thereafter, my lord.
Yes.
Nothing happened. Therefore, page number, my lord, 134. RTA reply was put up, and they have given the RTA reply.
Yes.
Page number 134.
134.
My lord, yes. Now, may I just to shorten the lordship time? Annexure 1, they mentioned point number 1.
Yes.
They mentioned Annexure 1 is a section 4 notification, which we read out already. And Annexure 2 is the section 6 declaration, which we have already opened.
Yes.
They have given. My lord. And the lease also they have given, my lord. My lord, Annexure 2 is the EAC lease, my lord. I'm so stand corrected. EAC lease. And Annexure 3 is the section 6 declaration.
EAC list means
EAC list,
name of names. List of names.
76. 71 names.
Third report.
Right, the third report. And I have repeatedly, my lord, annexed again page number 135. This is the AAC list. RTI. And the same missing names remain the same. No explanation. Those are missing names.
Yes.
Right.
Missing numbers, rather.
Missing numbers are.
There is no name. So we can say.
Missing number, right.
If you know arithmetic, then we will just say that. If you know the numericals, then we will say that there are missing numbers. We cannot say there are missing names.
Yes. Missing numbers, we can say. Missing number. And in the writ petition, we have taken a plea that these missing numbers are mine. And they did not reply. Until the position is, my lord, section 4 or section 9 notice, they did not revoke.
Yes, in the original record also it is like that, I think. Is it? That missing numbers?
It is the same thing.
According to him, missing names, we are saying missing numbers.
Missing numbers.
We'll have to verify, Roger.
You have the records with you.
Original records, no, Roger.
No, may I take lordship their affidavit? They are affidavit now.
Achha, then it's okay. Then that is what your thing. The reference to the.
Yes. No for the hearing was allowed or given to us.
But then you do not know when a word was prepared.
My lord, we are never informed.
You filed one representation on 13th September, and then you RTI application.
Subsequently, same month.
Same month.
Same month.
And after RTI, you received in 28 September 2015.
My lord.
Where is your RTA application?
But RTA application, my lord, the village level they did not annex. They submitted to the office.
I think your thing is not very fair. You see, like your
and they have
approach is.
They have given the information.
No, but then see, September 2013. That is your last representation, and you have not bothered even in between to even look for when a word was prepared or not. That is enough to. That will be enough.
Lordship, kindly see the date of my RTI application.
First September 2015.
Well,
read Annexure 12. The reply it says with reference to your application number nil dated 1st September 2015.
Lordship
Annex
is
12, page 133 of your
133.
writ petition.
133.
Yes.
Yes, my lord. Are they
That is prior to your representation. Your representation is 30 September. Representation which you have written
Yes.
for rehearing
Yes.
is 13 September.
September.
Yes.
Correct. And there was
30 September 2013.
13.
And that is 2015.
2013. My lord.
And that is RTA is 2015.
2015. Correct.
After 2 years.
After 2 years, my lord, they continue to approach. Nothing
You were
happened.
sleeping that time. They were not even.
My lord, the village.
Your land is not there. It has been taken. Others all have received money. You were diligent till
My lord.
section 9 and then you have not.
My lord. Thereafter, my lord, they continue to approach, my lord, without writing. And nothing happened. Therefore, they put up the RDI application. 2015. 2 years. We can say 2 years, almost 2 years. And they have given the reply. They have given the reply.
In reply, they have annexed this list.
Yes, this list. Same.
And then, what is the other part of the reply which is relevant for you? Any other part of the reply which is relevant for the purpose of this case?
My lord, this is annexure, section 4 notification also, 6 also. These are all RDI reply.
These are already there. You have already referred to
My
it.
lord.
Apart from all those things, any other thing you want to, this thing, to accept that list, which you say, that those phone numbers still remain missing.
Yes, still missing. Still missing. But
apart from that, any other significant thing here? Any other?
But subsequent representation papers are there, my lord. But now may I go to the pleading of the state?
No. What is the requirement of law when you find that after section 11 your name is not included?
Therefore, my lord,
under the Land Acquisition Act, what are the procedure to be followed?
My lord, my humble submission, respectful submission is, my lord, since the government has denied that they did not take my land.
No, my question is that, the question of the court is that, as per law, forget about what the government has said, just forget it for the time being. As per law, after section 11 is complete, a word is prepared. Okay. If a person find that his name is not included there, what he should do in accordance with the provision of law?
My lord, according to me, with due respect, this writ court is the only opportunity, the forum for those writ petitioners, the land loser, to approach before this
There is
court.
no other provision in
my lord, and to show that state action is arbitrary, illegal. Therefore, we approach before this court.
You are talking about something, state action is arbitrary and all. See, it is, the court's question is quite simple. When a name is missing in the list of claimants, in pursuance to the preparation of a award, see, we are not saying that the wrongdoings and all those. What is the normal process a person should? When the award was prepared, Mr. Khan?
It's very unfortunate. Neither I was checking the record. We're not finding it, Lordship.
That date will be required. That date will be relevant.
That date will be recorded. I was trying to glean through
That date will be very relevant.
In fact, it is
But
great
not-
for even production of the records.
How a writ petition, see, like, if you can procure everything by RTI, why not the award?
My lord, the level of the writ petitioners in the village level, they don't know the importance of data.
What about the RTI?
It was written in
RTI comes from the same level.
same level.
That is true, but my lord, the items of information they seek, my lord, they are unable to understand.
It is the question of res judicata do not apply in RTI. If you fail to apply
That is
anything, you
true.
can repeat it, file separate application.
That is true, my lord. But the villages, my lord, they are unable to appreciate the consequence
No,
of.
even when they come for filing a case, before that also, you see, preparation of this case without even knowing the date of the award, something basically the court finds very unusual. Because the award date will be very relevant here. Forget about having copy of the award, even the date of award is not known to any of the parties. And we are proceeding to decide a matter. We are hearing. 11A. 11.
So after section 9, you'll come to section 11.
That is what?
And
Enquiry.
one will come.
Section enquiry, then 11A is this thing.
Right. And thereafter section 16, they can take the position, take over the position. And whoever not satisfied, under section 18, they'll go for enhancement.
Lordship, can I assist the court on law point? Just to clarify the law, with the permission of the court.
Yes, yes, please, go ahead.
Lordship, if you just first come to 9, section 9.2. Lordship, the factual situation was the notice was issued under 9. Let me take the stand of petitioner to clarify why they are wrong. If notice was issued and they were supposed to appear on 19
Mr.
July.
Sangrishwa is not finished, I believe. If your thing is coming
Only
in the form of objection, then I think just allow him to finish and then.
Lordship. I thought only a law point in Lordship.
No, if I thought that like you will be placing something, would help us in.
9.2 Lordship, 9.2. Kindly then only law points Lordship. Kindly say 9.2 and 11.
11 though it's definitely, you see, after this thing, see, probably honestly I'm out of touch with those things. See, like,
That's what I'll just assess the court Lordship. Why 9 to 11 and 30 is relevant? 9 to kindly say Lordship.
yes, what does it say, 19? Yes.
Such notices shall state particulars of the land so needed and shall require all person interested in the land to appear personally or by agent before the collector at a time and a place therein mentioned.
Yes.
And to state the nature of the respective interest in the land and the amount of particulars of the claims to the compensation for such interest.
Yes.
And their objection, if any, to the measurement made under section 8. The collector may in any case require such statement to be made in writing and signed by party or his agent. Lordship, on 19 July, assuming Lordship on 19 July they did not appear. They file a letter on 13/7. There was no personal hearing required under section 9.2. So, this was I am trying to assess the court, Lordship. Their contention is this: nothing was heard, even on 13.
This is all right. This is what you are basically standing up now. You are refuting them. So I think that after he finishes, then
their application, they have nothing on record. Even they were not heard. Supposing for the sake of argument on 19 July, on 13 they have not brought out the nature of claim and interest they are entitled to. If you read the letter,
the entire contention of the petitioner that the name is not included at all, you see, would not stand in view of the fact that they had received section 9.1. They admit it.
Yes. And they have to
On
exhaust.
the day on which they failed, they did not make any representation there.
Correct.
And then they come to September.
Even on that day, they have not stated anything or complying
They did not fulfill the
92.
requirement what
92.
section 9.2 says.
Exactly.
They want, we fix another date.
Lordship. And Lordship will come to now. Now let's come to 11. No. If they have not exhausted the remedy under 9.2, either on 9 July or 13, then let's come to 11.
Yes.
11, clause 1, subclause 3.
Yes.
Lordship, that's why Lordship is very correct. We have to know the award at least. Absolutely correct. No denial about it.
No, without
Unfortunately.
award, definitely.
No, Lordship, what will
How they make their claim without
Absolutely. Now, Lordship, under section 11.3,
Yes.
the award under this heads of, first will be Lordship, number 1 is true area of the land. We are not concerned right now. Compensation which in his opinion should be allowed for the land, not relevant for a purpose. I am connecting 9.2 with now subclause 3. The apportionment of land compensation among all persons known or believed to be interested in the land, comma, of whom or whose name he has information, whether or not they have respectively appeared before him. Now, if this materials of 9.2 was exhausted on 13th September,
Yes.
he would have to, whether they have respectively appeared, appearance is immaterial.
Yeah, appearance even is through agent also. So that is
Exactly,
not that thing.
exactly. Then the last line says it is immaterial, provided the material was not there, and then
See, the normally section 9.1, when it seeks the interest person to come,
general notice, a public notice.
yes. And say supposing if you are not been able to come, you can send Mr. Shangupta as your agent. That is why by agent. So there cannot be an excuse that because of this I could not do. Because
Absolutely
of that.
correct. Okay.
Yes, they can say that I have not received notice.
But the Lordship, the subject matter of 9.2 is this agent or me being personally present. The substance is, the nature of claim is very crucial. Now that we do not find in 9 July or 13.
Yes.
Now if that situation was not present before it is an admitted case, which is not present, under 11A, 11 clause 1 subclause 3, the collector in the award would have never had an occasion to decide on that.
Definitely.
Lordship will kindly appreciate. If he never had an occasion to decide on that, then their case collapses only on non-compliance of 9.2, and there could not have been an occasion. The only limited purpose this court would require now is whether to see the award copy itself.
No, award is, but then see the
No,
copy
no,
of the award. We are especially the date of the award is needed.
Lordship is correct. Lordship will definitely get back. Now, Lordship, kindly appreciate it. If that is the situation, non-compliance of 9.2 was not done. It's an admitted fact. There was no occasion for the collector under 11.3 to even discuss that issue. My submission, in Lordship, would be the case, the writ petition fails on that. Now, the question of section 30, Lordship will come. 30 would come after award. First, we have to overcome at the stage of passing in the award whether this fact was present before the collector. Their admitted case is nothing on record what they have brought. Now, 30 would come in Lordship post award.
Normally, you will find that many person they do not follow section 9 and all. So subsequently, they come up with these things. But then what happens in such a situation? They file an application before the collector.
Collector refers it.
Basically refers
it
for determination under section 30.
Section 30. And now, Lordship, they get another opportunity under section 30.
Their application, say supposing, when on September 13, they filed their representation, they just filed it without even ascertaining whether there was an award existing by that time or not. Okay. Second thing, say supposing if at all an award was existing and they were aware that their name is not there,
Yes.
they did not make any prayer for referring their name.
Absolutely, Lordship is correct. Absolutely, that is a different aspect, Lordship. I was about to come to that. Now, I am into the
There
first.
are many loopholes so far as their claim is concerned.
No, Lordship, so far law, the legal point involved in the issue is this: if they have not exhausted 9.2, there was no occasion for the collector to consider or reject while passing award 11. So, in this true ground, Lordship, the whole case collapses. There is no other material, in fact, required to go into the facts. But yes, Lordship is correct. After now, Lordship, assume a situation now. After award, they move to the collector to refer the matter under section 30. Now, that would be a different situation before the court, whether they have exhausted the same argument that I am forwarding, they'll have to overcome that argument. Whether 9.2 was exhausted or 11A was duly complied or not. So, this is the only limited legal issue involved, Lordship. And that's an admitted fact. We'll just consider 19 July, what happened, and their reply on 13 September. And after 13 September, this is totally a blank situation. If you consider only this legal aspect, Your Lordship, this writ is not at all maintainable. There's no cause of action, in fact. There's no cause of action and there's no enforceable right.
Now the reply to Learned AG, you see that section 9, hearing is not required. Personal hearing is not required.
No, I did not say anything. Well,
Personal
actually,
hearing
it may not be.
still-
It may not
Now,
be.
You have to basically place the nature of your claim there, section 9.
Yes.
Okay. Personal thing is not in the sense that it is not required that Mr. Shangri should appear in person. You can send your agent. But then you have to place the nature of your claim.
right.
Okay. With regard to the rate,
Correct.
the area, everything, measurement, everything.
Correct.
That is what is needed.
Right.
To be placed.
Right.
Now, your application is, which you filed in September, what does it say? What is the contents of this application?
We reply for
Does it state
deposit-
nature of your interest? Do you say that I am holding this much land, these things then?
refixing for hearing. We pray for it because the collector asked for my appearance for hearing. So hearing opportunity was not given to him on 19th July.
No, opportunity was given. You are not availed.
No, my lord, that is the claim of the petitioner. We went there. The government is the petitioner also, but since the lease were not there, complete.
Achha, then
Therefore-
see, like in 19th, you have not been given
Yes,
a chance.
yes.
Then thereafter, when did you file representation?
But the next month, September, my lord.
19 July.
July, August, September, the next 1 month. After 1 month, they filed.
It means just to tell you that you were not given a chance to appear, you took more than a month. It was not done on the next day or maybe next week or something like that.
That's right, my lord. If lordship may take the specific development relating to that, just clarify what was the exact circumstances. Para 16 of my petition, my lord. Para 16 of my petition.
1 minute, Mr. Sandesh. Do I talk more than lawyers?
No, it's okay, but my lord, this interaction, my lord, effort is to unearth the truth. Well,
If there is too many disruption by this court, you can always tell.
my lord, it is a common effort to find out the truth, my lord. But lordship can is para 14.
Para 14.
14.
40 or
14. 1 4, my lord.
14.
1 4. After section 9 notice. Para 14. May I just read my lordship permission? Para 14.
Yes.
Well, that the writ petitioners accordingly appear on 19 July 2013 before the collector as fixed for and whole day waiting for their names to be called out for hearing of their grievances. However, despite of calling the names of other landowners and given them an opportunity by the respondent collector, the names of the writ petitioners did not call out, and therefore in the evening, they personally approached the officer of the respondent collector, who informed them in return that the respondent collector is in confusion as to how the section 9 notice was issued to them when their names did not appear in this section 4 and 6 notification. Further, they were informed that proper steps would be taken after verifying the records and give them equal opportunity for hearing to acquire their land. That was the reply. They physically went there. Now, para 16, my lord. That having further notice had not been served to the petitioners, the representation that is have been submitted by the petitioners to the respondent collector, wherein they expressed that they were the genuine owners of the land in question taken over by the respondent state, and their names as the landowners were also clearly reflected in serial numbers and in the statement of valuation submitted by the pro forma respondent KGTC. Therefore, under the above circumstances, they requested to respond collector to verify, kindly fix a fresh date for hearing and compensate for the lands. So they replied this because the section 9 notice was for hearing. Now when they appear, my lord, then they will give their claim. Therefore, the contention of learned AG that there was no record that I filed my claim. It is not required to file my claim because opportunity was given to me. If I appear, my lord, and there is no claim made by me, then they say there is no record, no record is there, how the collector can pass order. Correct. But my case is that you are not giving opportunity to me, so kindly fix the matter. They are not fixing. They are not disposing my representation. They are not recalling the section 9 notice also. Therefore, my lord, we approach before this court.
When the award came?
Award, my lord, there is, in
your representation was before award or after award?
My lord, but there is one averment, not to take a para 30, my lord. There it says, they have stated that the award was passed in the year 2013-14.
How can it be 13-14?
But
there must be a particular date of passing.
Particular date they were unable to, my lord. That date of passing award, Roshim kindly verify from the records.
No, that has to be verified. That has to be verified.
I admit that I have no specific knowledge with regard to this.
That is what seems very surprising. That is one vital aspect for you. And even if there was no response by the respondent,
yes,
after you filed that September 13
yes,
representation,
yes,
maybe if you had the information, if you had the information when the award came, you could have taken some steps. That is probably law, maybe it mandates something like that. Maybe.
No.
But then you have not done it.
But
making a simple prayer to the collector that see, in the list of claimant, my name is not there in the award. I have a claim, please my refer. My name to so and so. You have not filed any application after coming of the award.
But Lordship, here they
now, a litigant who can come to court, file a writ petition, cannot file an application before collector for requesting forwarding of his objection or inclusion in the thing, his claim for inclusion in the name of the claimants.
My lord, my humble submission is the collector is not the authority to include my name in the land acquisition process.
Who?
For reference, my lord.
Then
now,
who?
The collector.
Then who is the person?
My case is, my lord, Section 9 notice was issued to me. Opportunity not given to me.
No. Who conducts? Section 9 also is collector. Collector's duty.
Collector, that's correct.
See, in land acquisition, is collector, he is all in all.
Exactly. I admit.
Only thing is that award has to have the approval of the government.
Correct. He passed the award and approved by the
government.
government.
But then it is so far as the process is concerned, it's collector, and you say like collector is the not man who is the responsible for inclusion of your name.
No.
It is he.
No, I'm not saying. The contention of learning AG is that I should put up my detail.
Referring to 9.
Even, my lord, when I did not appear before the collector under 9, I should have asked the collector
Section 9.2
to
is
refer my name.
Section 9.2 is pre-award.
Section 9 is an opportunity to the
that is pre-award. Before award comes.
Before award.
Yes.
Before award. So that the collector can pass
Section
the
9,
award.
then Section 11 is complied with, then Section 11A says award.
Award will come. Award.
Now, say supposing when a person gets aggrieved for non-inclusion of his name,
yes,
when final award comes, and when he finds his name is not there in the list of claimants, but then it seems there was no effort by you even to know it. Now the list which you have included herein, under the RTI this thing.
Under RTI, this is an EAC report.
Is it the list?
Is the list EAC
or
report?
this is a copy of the same thing which this is the
thing.
EAC.
EAC.
We are not concerned with the list of EAC. We are concerned with the list which is appended with the award. The award, the names which is there in the award.
My lord,
that is what we have been reading first.
Award normally, award name is not required to publish under the Act. It is not
No, it is there available in the award. When the award comes, the names automatically comes.
My bad, award. So the
because the award will specifically will say Mr. Sangrecho this much, Mr. Khan this much, Mr. Sangipto this much.
Right. So the landowner knows that his name is there or not. Those whose name is reflected in Section 6 declaration, definitely their name should be there under Section 11 awards, and they are supposed to know. My grievance is Section 6, my name is not there. You issue me a notice.
It is not required. Section 4, Section 6 is not required. Whether name is included or not included it is no material at all.
Issue by
Your names, inclusion of a name after preparation of a word, that is what matters.
Therefore, so Section 9, between Section 9 and 11. Now, if Section 9 is complied with, my lord, and the collector rejected my prayer, there may be an order that rejecting you are not entitled for award.
See, Section 9, I don't think it contemplates that there has to be acceptance and rejection. That is taken consideration while preparing award, and that is why award becomes important.
That is why.
So, whose claim has been accepted and whose claim has been rejected, that is determined from the award. You will not pass any individual order.
Therefore, my lord, the collector will pass award under Section 11 on the basis of the record, read with Section 9 notice also, Section 6, Section 4. These are the documents material.
We have to know all those things when it happened.
In my case,
it doesn't have those informations.
Immediately, my lord, they did not seek the award, copy of the award or date of the award. And the village level, they did not know the importance of the date of award.
That will be required. This should be relevant for the purpose of deciding this case. That pursuant of Section 9 and pursuant to your non-appearance, what happened?
Lordship may call for the record.
Is it not for you to establish?
My lord,
you come by a petition and you say like you avail your...
My lord, with due respect, the citizen will go where?
Very surprising is that none of the parties are aware when this award was passed.
My lord.
That is what we are in a litigation proceeding, a case which is pending from 2017. And now for determination of that, now record is required.
They were informed that, my lord,
we refuse that prayer.
80% award was given to those other landowners.
You have not given enough materials for determination of, you say like creating a situation where we may need records.
But with due respect.
Now you have, what is this list has been given under your RTA application.
Yes.
Now what was your request in the RTA application with regard to this list? Where is your RTA application?
RTA application, same action.
Where is your RTA application?
The application is not annexed here, my lord.
So how do you know, even you have not bothered to even ask for a list of claimants? This is a list of ESC. We are not interested with ESC. ESC is not the final list of the collector.
Right.
There may be many preliminary lists, but then what is accepted by the collector in the litigation proceeding, that becomes a final list, and that matters. Where is that list? And you have not even asked for it also in the RTA application. You have not appended your copy of your RTA application.
The list of award.
Conduct of the writ petitioners become questionable.
My lord, that lordship has a discretion. But with due respect, my lord,
it is not discretion. You are given. You see, these facts are coming from there. Just say. At least you tell us what was your prayer in the RTA application. In the RTA application, you have specifically asked for which documents?
Well, lord, these are the documents I think perhaps they asked, and they have given this.
No, making a
lordship, the RTA is with the respondent. My application was the respondent. And the litigants, my lord, in the village level.
You file an application, RTA application you file without returning a copy with you.
My lord, this happened in many occasions, my lord. RTA applicants submit the original.
Many excuses can be taken also. And what is accepted, that is the matter. It is like it may happen many things. In the court, we just say about the acceptable things.
That is true, my lord. Here, if the RTA reply is not there also, then I cannot talk about the RTI. But now, RTA reply is already there.
Now, if you are basing your argument on this and saying that same pages or same numbers are missing here, which way this court will say this is a final list in the litigation proceeding?
Lordship, the state reply is very clear. They are not
state says that is the final list.
My lord, they are relying on this.
Where is that?
Lordship, can you see the government of the state? Lordship, I start from para 9. A lengthy reply they have given.
Yes. Wait. Please wait.
Para 9.
Yes.
My Lord, next. With regard to amendments made in Para 7 of the writ petition, the answering deponent maintains, as mentioned in reply in paragraph 5, based on survey and assessment report dated and such, preliminary notification 2012 in respect of 56 interested parties were published under Section 4 of the LA. The said notification invited claims and objection under such. Upon publication of the said notification under Section 4, as many as 26 claims and objections were received from interested parties. There were no records to show that the petitioners filed claims and objections under Section 5A. After hearing the parties concerned, the matter was referred for inquiry by EAC, such. The inquiry officer further submitted notice to all the concerned regarding conduct of inquiry. The inquiry report based on spot verification was submitted by EAC on such. This is the one we did talk about. In respect of 71 interested parties. 71 parties. The respondent recorded assets in respect of 64 new inclusions and 6 corrections based on spot verification. But no mention of the petitioner names were made, nor any assets recorded against their names. KHTC such submitted LA papers which contain abstract statement for valuation of the such interested parties listed from A to N, assessment in respect of original lease of 56 interested parties and new inclusion and 4 modification. However, lease for new inclusions contain names of 68 interested parties without mention of their assets. As proceeding under Section 5A could not be completed within stipulated time, is important matter. Publication of declaration was delayed, and ultimately fresh preliminary notification dated such, which we have open matter, 2013 was published, cancelling the earlier notification. The said notification invoked emergency clause. They admitted Section 17.4. Subsequently, declaration and such containing the 120 interested parties, landowners were published in such. It may be noted that when finalizing the list of landowner interested parties, new inclusion as suggested by earlier LA proceedings under Section A were incorporated in the said declaration. It may be mentioned that despite none in reflection of the names of the petitioners in the EAC list and such, their names appear in the Sunset KHTC, that is Sunset. It remains to be seen how the names of petitioners were reflected in the KHTC statement when report AC was predated the same. It may be mentioned here that when LA papers submitted by JDTC were examined, it was seen that abstract statement contained signatures of 3 KGTC officers and 2 other unknown officers, and therefore raising questions of veracity of KGTC statement regarding the names of petitioners, whereas EAC report was based on field inspection and spot verification. Moreover, since EAC report predated the KHTC report, it could be taken as more authentic over the later. Hence, the report of EAC was given precedent over the KHTC report for finalization of the list of interested persons to be published in the sections and such. So, the EAC list is only 71. Now, Section 6 declaration is 120. And since it is predated to KGTC,
KGTC all immaterial until and unless we see the list of claimants in the award.
Yes. Right.
Until and unless we see the list of beneficiaries, the person who has received these things, this will have, all this will lose relevancy once we see it. And the land acquisition matter, what about the thing and all? Your claim is whether that you have been wrongfully excluded or not.
Yes.
Okay, whether your claim is rightful or not, or your exclusion is wrong or not.
Right.
That is what. But then, if you do not have a list of the actual beneficiaries, these things, okay, which comes in pursuance to the award, which way you proceed in this matter? When it was prepared, nothing is not.
Lordship, we kindly have the court for the record and satisfy Lordship.
See, some material has to be there. Nothing.
And Section 9, with regard Section 9.
No, what is the base of your case? The documents basing on which you are making out a case, I don't think you can make out a case.
No.
Nothing.
Lordship, then what is the fate of Section 9 notice? Mention all my properties.
See, Section 9, you have not appeared and you have filed an application. After application,
yes,
After 3 months.
Right.
That is enough. That is conclusive.
Right.
We can hold it that these things. And plus your petition doesn't even mention anywhere when award was prepared and all those things. So that we can always say that you had never had any real
Lordship, the collector, with due respect, collector has to answer. That okay, Section 9 notice we issue to you, verify you're not the landowners.
So he has. I think in his affidavit he has given some reply to that.
My lord, they just say that the mere issuance of Section 8 notice, Section 9 notice do not confer any rights.
Where is that reply?
I'll come to that. But, my lord, that would be better.
Calling record will be useless now. The records of so many these things. It is 2013, 14 maybe. 10 years now.
Right. Let's just come to that para. My lordship, can you come to para 16 of the state affidavit?
Yes.
Well, with regard to the vermins and allegations made in para 14 of the writ petition, the answering deponent humbly states that, as mentioned in para 7.
No, come to section para 15, Mr. Sangresha.
Para 15 or something, yes. With regard to vermin made in para 13 of the writ petition, the answering deponent humbly states that notice under Section 9 was issued to the appellants by referring to statement of valuation prepared by KGDC only, whereas it should have been issued as per declaration.
Yes.
Now, this was found out only later after cross-checking with the declaration which contained final list of landowners interested parties based on the report of EAC. Now, the answering deponent humbly states that mere issuance of notice under Section 9 does not provide for any entitlement. Right.
Yes.
Moreover, there are no records to show that the petitioners appear for hearing on under Section 9.
Yes.
Now, Section 9 by
means they declined. It means they declined. You are not there. You are not there. Then.
But they are not passing any order in my representation also. And now they say that, oh, we issue notice Section 9 wrongly based on the KGDC and competent authority.
They have not issued any this thing. See, this case we filed in 2017.
Yes.
Now we are in 2020, 6 years. His representation is 2013.
13.
Now, if they have not replied, what can we do now?
Lordship has the power to examine my law. Otherwise, the land might not.
Examining, Sangresha, we are doing the exercise.
The land of my lord.
See.
How the citizen, my lord, how the citizen we allowed to lose.
There is no prima facie material to show that your land has been taken. Forget about this. You are not to establish a case on the weakness of the respondent. At least something should be here that you say this is my land. Where is your land? Where is that? Where is the details of your land?
My details of my land.
Where you have given?
My land.
And what documents you have given in support of that?
Come to the affidavit.
And have you furnished all those copies along with your representation to the
respondents stay here?
Collector?
No, my
Then why? Then what basis they will assert in your claim?
I'll show my. Lordship, can you see
proof
my
of land has to be documented.
Lordship, can you see my additional affidavit which we filed on?
Additional affidavit?
Yes. Without serving, how can we file? There is a procedure. There's a procedure. Number of time my friends sought for copy for
they do not have. Please give them a copy. Do not fight over small things.
But we can give. Number of time my friend.
Please you give them. Please you give them. Have a fair contest. Why to have unfair contest?
Definitely, madam. I supplied 2-3 occasions for reconstruction of the documents.
This time we will record. We will record.
And my friend,
this time we will record.
My friend is saying that no documents supplied to him.
These are small things, Mr. Sangresha, you should avoid. Yes, where what?
Madam, para 2, may I come to para 3?
Para 3 of?
Of my additional affidavit.
Additional affidavit.
Madam.
What is para 3 at page 2? What?
At page 3, madam. At page number 3.
This regent affidavit filed the petitioner in reply to the affidavit of
additional affidavit filed by the writ petitioner on 11 September 2019.
An additional affidavit.
Additional affidavit. An additional affidavit.
This additional affidavit comes after rejoinder.
My lord, this would be,
You, after affidavit of opposition, you have filed?
yes, after rejoinder, after rejoinder.
After rejoinder, then again additional affidavit.
Additional.
You are permitted by the court to do that.
It is there.
Yes, what paragraph? Paragraph 3.
Para 3, my lord.
Yes.
May I just read? No, the aforesaid Nogma did not mention the exact area of the allotted land given to the petitioners therein. It simply submits that approximately the area of land of the petitioner number 1 is 100 square meter, more or less, out of which 80 square meter, more or less, has been taken away, as clearly indicated by the record prepared by the district council. Similarly, approximately area of the land allotted to the petitioner number 2 is 180 square meter, more or less, out of which 14 square meter has been taken away. Similarly, the approximate area of the land allotted to the petitioner number 3 is 80 square meter, more or less, out of which 24 square meter had been taken away by the respondent state. Similarly, approximate area of the land allotted to the writ petition number 4 is 90 square meter, more or less, out of which 33 square meter has been taken away by the respondent. The writ petition number 2 had given constructed Assam type house in.
Where is the document support in support of your things?
My lord, this
allotment? You said allotted?
My lord, this, can you see page number 8 or so? There is one document given by the Nogma, the type copy.
Yes. What is this? There is no reference, no date, nothing. What is this?
This was given to him. Originally is there in page number 9.
There also no date, nothing. No reference, no date.
And page number 10 is another.
These are not at all admissible documents. Nogma certificate. Now you say that allotment is?
Page number 8 document is for writ petition number 1. Meriti Marak.
Yes.
Page number 10 paper is allotment in favor of writ petition number 1. Meriti Marak.
It is a Nogma certificate.
Nogma certificate.
NOC.
Marak.
No, but then doesn't prove your ownership over land, any land.
No, this is the allocation. What they do.
Nothing, there is no price. See, at least something should be there to at least to make this writ court move. See, except for this section 9, this thing, nothing is there.
Well, not. Then I don't know how they prepare the section 9 notice.
If they have prepared also, what right is created in your favor?
My lord,
and which you have not responded.
My lord, we have responded to our representation.
No, they have said that there is no record. Representation in September. And this government is not bound to reply to each and every representation.
My lord,
your representation also, there is no acknowledgement when it was received. At least something is needed, something.
This is how in the village level, my lord, it functions. And the writ petition was 10 rules. Exactly, my lord. They have taken, if lordship, for the sake, my lord.
Anyway, you try to ascertain the date of award.
Award, my lordship.
If you can, or try to get a copy of the award. Or you can, see, we do not want to call for the records.
They can produce in their record.
You do not want to call for the records? This will be bulky and 10 years old record.
Absolutely.
In the government office, if you call for the record, it will remain in what shape?
We don't know.
If we can get only as a copy of the award, along with the list of claimants, of course the award will come that way because there will be
absolutely
allotment of amount to
section plus the award is very clear.
So that will at least make us some, just to
only
satisfy ourselves with the contention of this.
Kindly accommodate sometime. We'll come back.
Just try to procure it by these things.
Lordship, just the other day also we had a similar situation. We had given a Xerox copy of the inquiry.
Are you needing this thing judicial order for that or
no?
You can make it this.
No,
so Mr. Sangreso, let us just see how much help. See, you are trying to establish a case on basis of their affidavit. Now wait, now they will provide the documents so you can have.
I really feel sorry for the landowners.
No, that much was expected. At least the date of award. From 2017, this case is pending here. Okay, parties they do know, at least nothing. Which way you determine? Just tell me. Whether it's a list of ESC, it's a list of GHTC and all those things. This what implication it will have in Land Acquisition Act?
Your Lordship,
The Land Acquisition Act,
the inquiry.
the document which is prepared by the collector, that would basically become final document in respect of the proceeding. Nothing else.
No, Lordship,
For
see,
instance,
Lordship,
Lordship
this,
direct
see,
for inquiry. Inquiry, my lord, if conducted, my lord, nobody will come and claim my land.
And
They will
you see,
definitely say that
we'll
it's my
take
land.
notice of that also, that you said you have not received adequate compensation.
No, there is no. that order is no longer
You
served.
have received,
that's not received. That
and
was not,
whether it is adequate or not adequate, this writ petition will not.
My lord, that order is no longer survived. It is buried forever, my lord.
but Lordship, that's a
That
series.
was not
It's
a
a
submission of
judicial
the
order which travelled to the division bench.
That was not a submission of the party.
That's subsumed before the division bench.
My lord, that
No,
there was
Lordship,
a
if we handle writ matters so casually, Lordship, then I don't know.
my lord, that was not the submission of the parties.
He
From
could have
our
filed.
side, from
He
our
could. He
side.
could have filed review.
That was the submission of the state respondent.
He could have
On
filed
that basis,
review.
a single bench passed that order.
Anyway, we're not going to
And
that.
division bench also learned AG vehemently opposed my writ appeal, said that I should invoke a section 18. That was turned down by the division bench.
I don't know. Nothing is on record. Lordship, what?
Doesn't it
Besides the award issue, Your Lordship.
It's a social welfare legislation that it's easy for the government to say that no, we don't acquire land.
Lordship,
Yes, and this beneficiaries of social welfare, if they behave like this, then it becomes difficult. You see, you should be ready to accept it. Whatever the welfare comes, you see, do not expect that government will come, will knock on your door and will give you money. At least something is expected from your part.
6-9 is an inbuilt provision, Your Lordship. 9-11 is inbuilt provision. Now, Lordship will only consider one matter besides the award. Lordship will just kindly consider the 13th September letter. And there are two very important principles of law is involved.
See, this court is basically already has expressed its
No,
thing. See,
we went to that.
Till now we have said that you see, like there is nothing, no material
No
basically.
material.
And there is precisely the reason court is not even inclined to call for the records also.
Absolutely, Lordship.
Why to it's unnecessary, you see, like burden the courts itself.
Your Lordship, my only.
Until and unless there is something.
No, Lordship, Lordship will kindly appreciate. If
Very surprising is that if at all there is an award and at all there is a list of claimants and if they find their name was not there, why no representation was made to the collector for inclusion of their name? Even say supposing,
That is correct.
say,
Absolutely correct.
just
Absolutely.
take a situation where in section 9 they respond.
Yes.
They are hard. They place their point.
So, Lordship, that is what.
And thereafter, after section 11 comes and all,
Lordship, if
the
I may
award,
just-
their name do not appear.
Lordship, if I may
What
just,
they do?
Lordship, if I may just assist the court. 9 is inbuilt mechanism. 9, 11, 12 and 30 are inbuilt mechanism. They get 4 opportunities to correct. Nothing happens in 9 on material, they can rectify in 11. Nothing happens in 11, they can rectify in 12 when the award is made. Still nothing happens, they can file a representation to 30. No other legislation has got this inbuilt mechanism.
There is no
What
notice
you
under
can
section
see?
11.
12. 9, 11, 12. No, the only submission in Lordship is this: they have not brought those material facts on 13 September. Another law will be applicable. Lordship, they have waived the right themselves by their own conduct.
But then the thing, you see, like government affidavit also something.
No, Lordship is correct. Lordship, we are not denying what is the affidavit part, Lordship. Because, as my friend rightly said, Lordship, we still don't understand how did the GHTC inquiry report found echo, and then we have said in affidavit. Government is also surprised how the notice was issued on 9. Lordship will kindly see 9, 11, there's a read out, and you see 12, and then you see 30. There are 4 occasions for alternative remedy.
Please try to ascertain, just try to get a copy of the award. We'll just see.
We'll do it. Otherwise, Your Lordship, on the principle of waiver.
We'll just say. We'll take 2 weeks.
Lordship, yes.
Will be enough. Mr. Sangresh, you let him produce the order.
We'll try to get the extract.
Well, heard. So and so. For the petitioner, on the prayer of the parties, list of weeks. We'll have more matters. Yes.
And, item 3, the next item. My lord, here my friend was to... Yes, I prepared the list updates, everything is there. So, my lord, we have not received a copy of that also.
Item 3. What is that case? Was it?
Regarding appointment of the science teacher.
This is that school teacher.
But the lordship has heard us at length and allow me to give the list updates. Come up for hearing today. This update, everything is prepared. Well, I'll provide the copy. Perhaps my friend is not ready in the second half.
My lord, my apologies.
Any difficulty?
Yes, I'm ready.
Yeah?
Otherwise, I'm ready, my lord.
You are ready? Then we will see it in the second half. You have any difficulty?
I have some difficulty.
Spell it out. You just say it. Why you is in it? If you want to say something, just say it.
My lord, I have some personal difficulty.
What about the thing? You are ready to accommodate him or not?
Well, your lordship may take up next week. Otherwise,
next week maybe we do have these things. That will come after vacation. On the request of the learned counsel of the respondent, after 2 weeks, list after 2 weeks.
Yes.
You say it clearly. What is there? If you want these things, you just say whether court grants time or not is a different thing. But then you should say directly. Normally, until and unless there is, you see, like there is any objection from the other side, this court till now has not declined any prayer. Only it has reservation if no cases. That is what.
Well,
So, there will be
3 and 4.
3 and 4 are connected matters. So the same order will suffice. We do not have to come back in the second half. Nothing is there. Oh.